Hello, and thank you for watching. My name is Bradford Roberts, Principal Broker, Founder, and Owner of TR Realty in the Las Vegas area. After watching this video, please be sure to like it as well as subscribe to our YouTube channel. Download the pertinent handouts for this video by clicking the link in the comments below. Now let's get started. All right, let's talk about property owners. And I'd like to begin this segment by talking about what's required in order to initiate a new property management account. So grab a pen, grab a piece of paper. Here is the list of things required to take a new property management account at TR Realty. We need the duties owed. We need consent to act. We need the residential property management agreement. We need the TR Realty property management disclosure. If the property was built before 1978, we're going to need the lead-based paint disclosure. If the property is located within a common interest community, we need the rules and regulations. If there's a warranty on the property, we need information on that warranty. We need proof of insurance with TR Realty named as an additional insured. We need to check public records so that we can determine there's no notice of default or summons and complaint filed against the property. We need the owner to provide us with either a W-9 or, in the case of a foreign investor, a non-U.S. resident, we need a W-8. We need the owner to have a U.S. bank account. We need owner reserve funds, which should match or exceed the repair limit in the property management agreement. And of course, we need keys and remote controls, garage door openers for the property, that sort of thing. So we're going to go through some of these, specifically the property management agreement, in great detail. The others are mostly covered in other videos, so feel free to go and watch those videos. So let's get started with the PMA then. Go ahead and pull out the property management agreement, which I will refer to as the PMA from this point forward, and let us begin going through that property management agreement. So at the very top of the document, it says this property management agreement entered into this blank day. This is the term of our agreement. So at the top of the document, it says this property management agreement is entered into this blank day by and between. So we will put today's date on this agreement, and then we will put the owner's name. And on line 4, we will put TR Realty, because this is a contract between the property owner and the broker. And then it says by and through its authorized agent. So on line 5, you want to put your name as the permitted property manager / licensee. And then followed at the end of line 5 by your property management license number. It really should say permit number, but we don't mess with their forms in any way. Who is duly licensed to manage the property. In consideration of the mutual terms of this agreement, the parties agree as follows. Let's get into paragraph 1, which is notices. So any notices, demands, consents, and reports necessary shall be addressed as follows. From lines 13 through 18, we want to enter the owner's contact information. And it's important that we have all of this stuff, not just their name, but the address where they will receive things from us, like notices as an example, which obviously is not the property address, right? Which is why they're looking to rent it out and get it managed. We need their phone number, their fax number, their email address. All of that has to be filled in. And to the right of that, lines 13 through 18 would say TR Realty with the address of the branch where you're doing property management, the phone, fax, and email. Your email address would go there as well. Moving on to paragraph 2, it says employment of managing broker. 2A talks about employment and acceptance. So owner employs broker as the sole exclusive agent of owner to lease and manage the property, which includes listing the property for lease and securing a tenant upon the terms and conditions provided herein. So that is a formal establishing of the relationship between the property owner and the broker. And then it goes on in paragraph 2B to talk about the relationship of broker to owner. The relationship of the parties to this agreement shall be that of principal and agent, and all duties to be performed by broker under this agreement shall be on behalf of owner, in owner's name, and for owner's account. So again, first we have the establishing of the relationship, and then we have details of the relationship. Paragraph 2C is a description of the property. It says the property to be managed under this agreement is more fully described on Exhibit A attached here too. So we will be getting into Exhibit A a bit later in this video, where we actually break down some of the details, some of the specifics, terms, and conditions of the property to be managed and rented. And in paragraph 2D, that's our term of this agreement. It is typically a year, but there's no law or requirement. There's no minimum. There's no maximum. It can be whatever the property manager and the property owner agree, but it is typical and common to be a year, so that is what I recommend. And moving on to paragraph 3, paragraph 3 talks about broker compensation and expenses as compensation for the services rendered by broker under this agreement and exclusive of reimbursement of the expenses to which broker is entitled hereunder, owner shall pay broker as follows. So paragraph 3A, starting on line 10, broker shall be paid the greater of some flat dollar amount per month or some percentage of the monthly gross collected rents. Well, we allow our property managers the flexibility to do either, but it is highly recommended for a residential property that we go with a percentage. What is that percentage? Well, at TR Realty, we allow the property managers to do what they wish, but it is typically between 7 and 10%, with the focus usually on 8%. The reason to go down to 7% might be that the owner is giving us multiple properties to manage. And the reason to go more toward 10% might be that it's a challenging property. It might be that the property is older. It's going to take more maintenance, maybe more repairs. But generally, we go in that percentage range. And fast forwarding to line 12, where it says a vacant property fee shall be paid to the broker in the amount of some dollars if the property is vacant. So some property managers charge to manage vacant properties. That is almost always the case in commercial real estate, but our property managers do have that flexibility. And there are some times that you might be hired to manage a property where there's no intention to rent it out. It could be a vacation home for someone, or it could be awaiting the owner's retirement. Who knows? And they just want someone to watch the property. Well, since we typically get a percentage of the rent as our income, if there's no rent, there's no income, that might be a case to use this flat fee amount. So typically 0 here when we are going to rent out the property. But if you are anticipating vacancy or some other circumstances, you might think about putting a flat fee here in line 12. Moving on to 3B. 3B talks about a leasing fee. A leasing fee is property management speak for the listing side of the commission. In a courtesy listing where there's no property manager, we would refer to that as the listing side of the commission. But in a managed property situation, we typically refer to that as a leasing fee. So that is the fee for the procurement of a tenant for whom a lease is signed. And again, our property managers have the flexibility here. They could put in a flat fee amount, or they could put in a percentage, but we really recommend putting in a flat fee amount for that. And then it says, or a percentage of the annual rent. We don't recommend that we use it that way. We recommend that flat fee on line 16. Paragraph 3C talks about a setup fee. At TR Realty, most property managers waive the setup fee. It is much more common in commercial real estate. Also, to be very candid with you, there's a lot of companies out there that like to discount their percentage because they know that people are shopping that percentage. Typically, people don't ask much about the setup fee. So some other property management companies will advertise a lower percentage, but then hit people with a big setup fee. Typically here at TR Realty, we don't have a setup fee. Like I said, it is typically waived. 3D is the referral commission. So when we're talking about a referral commission, we're talking about the amount that we're going to offer to the procuring broker, the broker who brings the tenant, okay? So if you were to waive this, there'd be nothing to offer, and therefore chances are the property would sit vacant unless we were able to rent it out ourselves, which we could, but the pool of available tenants would be overwhelmingly diminished. So we do want to have a referral commission in there. My recommendation is a minimum of $300. If you're getting into a property that might be tougher to rent, if you're getting into a property with a higher rent, you certainly want to go more than $300. $300 would be an absolute minimum. And something to discuss with your owner is that the higher the referral commission, the more interest the property is going to get, right? When other agents are out there showing property, they go into MLS, and they favor the properties that have the higher commissions. So property owners might think, well, I'd rather pay a $300 commission than, let's say, a $400 commission. Sure, it sounds like it's saving them $100, but keep in mind that it's increasing the chance of the property remaining vacant as well. So sometimes it's a case of saving a few pennies and losing some dollars, all right? Let's go to 3E, which is the lease renewal paragraph. Typically at TR Realty, our property managers do not charge for lease renewals. It's much more common to do that in the world of commercial real estate, but that's where we are with that. So 3F is advertising, also typically waived at TR Realty. Again, common in commercial real estate to charge advertising fees. You can do it legally. You have the right to do it. It's just that we don't usually charge for advertising fees. That is part of the service that we provide. Paragraph 3G talks about interest on unpaid sums. If any sums are due to the broker and not paid within 30 days, they would accrue interest. We want to fill in 10% here, even though this is an extremely rare situation where this would happen. Paragraph 3H is about extraordinary services. So an extraordinary service is defined as a service that we provide to an owner that is not a regular part of managing a property. So example, if an owner wanted us to allow contractors into the house because they decide to renovate between tenants or something like that, we would charge an extraordinary service fee. And at TR Realty, we charge $75 per hour for those extraordinary services. Paragraph 3H talks about termination fees, that there might be additional fees in the event of an early termination of this agreement. We're going to talk about that later. Paragraph 3J talks about collection fees. In the event broker institutes any action for collection of amounts due and payable, hereunder, owner shall pay, in addition to the amounts due and payable under this agreement, all reasonable costs and attorney's fees. Again, highly unlikely, especially at TR Realty, with the way we do business. Paragraph 4 talks about bank accounts, and 4A talks about the trust accounts. We've covered that in an earlier video in this class, how the brokers are required to establish trust accounts. I've mentioned that here at TR Realty we do have 2 trust accounts. One is for owner reserve funds and rents, and the other one is for security deposits. Another way of looking at that would be one is for owners' funds and one is for the tenant's funds, right? Because security deposits belong to the tenant. 4B talks about the initial deposit and reserve. So when I gave you a list at the beginning of this video of things that we need to take into account, I did mention the owner reserve funds. And I highly recommend that when we set the owner reserve, we set it equal to or greater than paragraph 12A, which obviously we're going to come to a bit later, but that is the repair threshold. So it wouldn't make a lot of sense if the property management agreement allows the property manager to do a repair up to, let's say, $400, but then we only take a $300 owner reserve, right? Because we have the right to do a repair up to $400, but we don't have the funds to do the repair up to $400. So that would cause some confusion and extra work for us. So the amount that I recommend you put here in paragraph 4B, line 11, is equal to or greater than the amount that you put in 12A. An exception to this would be in the case where a property owner is asking us to pay a lot of their bills. And we do have property owners, and I mentioned in an earlier video that we provide this service at no cost, but we do pay bills. Some owners ask us to pay their bills. Sometimes we pay their HOA, we pay their insurance, we pay their property taxes. In some cases, we even pay the mortgage payments for the owners. It's up to their comfort level whether they'd like us to do those things or not. We're happy to do them. But obviously, if we're going to pay those kinds of bills on behalf of the owner, we have to have the funds to do so. So in that case, the amount that we put on line 11 is going to significantly exceed paragraph 12A, right? Depending on the unique circumstances. If somebody's mortgage payment is $3,000 a month and they're asking us to pay it, it wouldn't do us a whole lot of good if we have $400 in the owner reserve account, right? So we have to keep that in mind. Paragraph 4C is the security deposit trust account. Broker shall maintain a separate security deposit trust account for security and other deposits. We've already talked about that a couple of minutes ago. Let's move on to paragraph 5, which talks about collection of rents and other receipts. 5A, broker shall collect all rents, charges, and other amounts receivable on owner's account in connection with the management, and such funds shall be deposited into the trust account. We know that. Paragraph 5B, special charges. If permitted by applicable law, broker may collect from the tenants and retain any and all, but not limited to the following: administrative charges for late payment of rent, a charge for returned or non-negotiated checks, interest, rental application fees, and other fees as well. Paragraph 5C, broker shall collect a security deposit and deposit it into the trust account and disperse it in accordance with Nevada law. Any interest earned on tenant security deposits shall be retained by broker. So yes, we have the right to do that, but at TR Realty, none of our trust accounts are interest bearing. As I mentioned in an earlier video, I think it might give some brokers an incentive to hold on to the tenant security deposit or owner funds longer than necessary because they're earning interest. So we don't do that here at TR Realty. Let's move on to paragraph 6, which talks about disbursements of rents and other receipts. 6A, from the trust account, broker is hereby authorized to pay for all expenses and costs of operating the property. And then it says, you see lines 35 and 36, including broker's compensation. So what that means is we have the right to deduct our management fees from the owner proceeds or the owner draw. 6B is debt service. Owner shall give broker advance written notice of at least 30 days to make any additional monthly or recurring payments, mortgage indebtedness, general taxes, special assessments, insurance premiums out of owner proceeds. So we've already talked about the fact that TR Realty is happy to pay these bills at no additional cost. What this paragraph is saying is that you've got to give us 30 days notice to do that. Because, we may have to change the account information, the mailing address with the vendor, those kinds of things. So there's a little bit of a lag time for that, a lead time, I should say. Paragraph 6C, to the extent that funds are available, and after maintaining the cash contingency reserve amount as specified in Section 3B, broker shall transmit the cash balances to owner or as otherwise directed by the client in writing. Net proceeds are defined as the amount after all costs and expenses are deducted. So it's a very important paragraph because, number one, it defines how much money the owner is going to get, right? They're going to get the rent minus the management fee, minus any expenses. But there's potentially another minus as well. And that is stated clearly on line 45, where it says, after maintaining the cash contingency reserve amount. So if that owner's reserve account were to be tapped into or depleted to some degree, that would be automatically replenished out of the next rental income before we disperse the balance to the owner as the owner's draw. So that paragraph gives us the right to do that. Paragraph 7, broker is not required to advance funds. And in fact, at TR Realty, broker is not going to advance funds. I think that is really, really in the gray area of commingling. So we're not going to come anywhere close to that line at TR Realty, okay? Let's go to paragraph 8, financial and other reports. Owner is required to file IRS forms. There's reports. There's FIRPTA. I've covered FIRPTA in another video, Foreign Investment in Real Property Tax Act. So I'm not going to cover that again now, other than to point your attention to line 22, where it says owner is or is not a non-resident alien individual, fiduciary, foreign partnership, or foreign corporation. That cannot be blank, because there are ramifications there, legal ramifications, tax ramifications, and accounting ramifications. So we need the owner to initial their initial, please, not a check or an X, but please have the owner initial, owner is or is not a non-resident alien. That's really important. All right, moving on to paragraph 9, which is leasing and renting. As you can see with the form in front of you, 9A gives us the authority to negotiate, prepare, and sign leases, including renewals and extensions, and also to cancel and modify existing leases. So this is like a limited specific power of attorney that is granted to the broker when the PMA is signed by the owner. 9B, very similar, but this is about enforcement of the leases. So this gives us the authority to enforce the lease, or for that matter, choose not to enforce the lease, maybe depending on the circumstances. Gives us the authority to institute legal actions or proceedings if that was necessary. 9C, management and maintenance review. Broker shall make management and maintenance reviews of the property at the time of occupancy, so that's move in. When the tenant vacates, that's move out. And at other such times, broker feels necessary. So those interim property inspections are really at the discretion of the broker. Now, with the virus raging on, we're not really doing these. In fact, until recently, we couldn't do them. They were prohibited by the governor's directive. Who knows where we're going with that in the future. But of course, unless there's reason to believe that something untoward might be happening, some kind of emergency, some kind of a problem, it is highly advised for property managers to stay out of the properties right now. Taking a look at 9D, which is authorization for us to install a lockbox, or as they call it here, a key box. Cannot be blank. Line 43 must have a choice. We really like initials instead of a check mark or an X. And of course, allowing us to put a lockbox on the property is always advantageous. Now at TR Realty, we only use electronic lockboxes. We do not use the old mechanical lockboxes. Why? Because with a mechanical lockbox, if the key code, if the lockbox code is disseminated in any way, anyone can get the key. Anyone can get in there. There's no record of who is going in or when they're going in. But with the electronic lockbox, we have a complete record of when that box is accessed, who accessed the box, when the box was closed, etc. So much more secure for the owner and for the property. So please, no mechanical lockboxes at TR Realty. And then 9D, subsection A, the purpose and function of the key box is to permit access to the interior of the property by all members of MLS. So that's really important. We want to grant access to our fellow realtors. And I want to bring your attention down to 9DD. So paragraph 9, section D, subsection D as well, where it says where a tenant occupies the property, the tenant's consent is also required. So just a friendly reminder here that not only would we need the owner's consent if the property was already occupied by a tenant, but we would also need that tenant's consent as well. Sometimes we start showing a property long before the lease is going to expire. If we know that the tenant is not going to renew, or if we're not going to offer him a renewal, so that might be the case there. Now, very importantly, in 9DE, subsection E, owner does or does not authorize broker to issue one-day codes. I don't like one-day codes. Actually, I think it was kind of a mistake that our association provides lockboxes with one-day code capability. And that's because so many lazy agents and property managers are actually giving one-day codes to the public. Now, this is a huge violation, by the way, and a ridiculous, stupid, irresponsible way to do business. I understand the original intent of a one-day code was perhaps for a vendor, if we wanted a cleaning company or a handyman to go into the property rather than put a mechanical box. Now we can use the one-day code on the electronic box. So these electronic boxes that we use, they're called Sentry boxes now, do kind of give us the best of both worlds, but they didn't really take into account the fact that realtors would give them out to the public. Folks, never, ever, ever, ever do that. That is a huge violation. And like I said, a very irresponsible way to do business. Regardless of whether you want to use one-day codes or not, we need the owner's consent. We need initials here in this paragraph. All right, let's move on to paragraph 10. As you can tell, this is a kind of a simple and quick look at this form. It would take hours of video were I to go through every single word of every single line. You still, folks, if you are serious about property management, and if you are already a property manager, you need to work to read and dissect and understand every single word of this PMA, not just the things that I'm highlighting and bringing to your attention. That is the way you need to do business. And anyone who's watching this video who might have any questions on something that I didn't cover, feel free to text me anytime. And I'm happy to help you whether you are with TR Realty or not with TR Realty yet. All right, let's take a look at paragraph 10, which is the multiple listing service. Broker is a participant. It says here GLVAR, but as most of us know, GLVAR changed their name recently to LVR. Paragraph 11 is the opt-out paragraph. which ostensibly allows an owner some control, whether they want their property displayed on the internet at all, whether they want the address of the property displayed on the internet, whether they want a commentary section or a valuation section. So they have the right to opt out of some of those things. But folks, for our purposes, we really want initials down on line 49, meaning that the owner is not opting out of any of those choices. Of course, anything that they opt out of, restricts us in some way. Ties our hands together, if you will. So that's why we prefer that the owners don't opt out of anything. Paragraph 12 is a really important paragraph, and in fact, I referred to it earlier, mostly 12A, ordinary and emergency maintenance repair. Let's look at this one quite carefully. Broker shall make or cause to be made through contracted services, employees, or otherwise, all ordinary repairs and replacements reasonably necessary to preserve the property in a habitable condition and for the operating efficiency of the property, and all alterations required to comply with lease requirements, governmental regulations, and insurance requirements. Any cost exceeding some dollars, we'll come back and talk about that, must be approved by owner in advance, except that in an emergency where repairs are immediately necessary for the preservation and safety of the property, to avoid the suspension of any essential service to the property, to avoid danger or life of property, and to comply with federal, state, or local law, such emergency repairs shall be made by broker at owner's expense without prior approval. So let's go back and look at line 8, and that is the threshold that you've heard me refer to, under which the property manager has the sole discretion to conduct a repair, over which the property manager is required to consult with the property owner and determine if the owner wants to proceed with that repair. So this is typically around $300. Unless it's an older property. If it's an older property, we might want to go a bit higher because, again, an older property is going to take a lot of maintenance and a lot of repairs. So we need to have an amount in there. And as I said earlier, we need to collect owner reserve that matches or exceeds the number that we put here in paragraph 12A. And then the other important part of this paragraph, which I read, talks about the definition of an emergency. So we are required, it's the right thing to do anyway, even if we weren't required, to ensure that a property is habitable, okay? So as an example, if an air conditioner breaks down in January, it's probably not that big of a deal here in Southern Nevada. But if an air conditioner breaks down in July, it could be life-threatening. It could endanger the residents of the property. So the property managers have to have the discretion. They're the ones who are completely plugged in to the situation at hand. They have to be able to do what they need to do to preserve the health, the well-being, the safety of the occupants, as well as the property itself. So, we've seen cases where owners have become upset about this. Well, what do you mean you authorized this kind of repair? You didn't consult with me, or it's over the limit in the PMA. Well, folks, when the property manager determines in his or her sole discretion that the issue constitutes an emergency, the property manager has the right, has the obligation to act on that. Okay, so that's what that is about. Let us move on to paragraph 12B. At owner's expense, smoke detectors will be installed on the property in working condition. Okay, but then during the occupancy, it shall be the tenant's responsibility to maintain the smoke detectors, to test them on a regular basis. That's in the lease anyway. To replace the batteries on a regular basis as well. Paragraph 13, utilities and services. Owner shall, in owner's name and at owner's expense, make contracts for electricity, gas, or water, or such other services as necessary or prudent for the operation of the property. Now, we've had some owners who think if the property's vacant, then they can just disconnect all the utilities. What's going to happen to the landscaping? What's going to happen to any mold that might be growing in the property? How are we going to show the property accordingly, right? The property is going to deteriorate. That's a very foolish owner. So we need to keep those utilities on during the vacant time, and that's what this paragraph is about. Let us zip down to paragraph 14. It talks about insurance. 14A, owner's insurance. Owner shall obtain and keep in force adequate insurance against damage and against liability for loss, damage, or injury to the property or persons which might arise out of the occupancy, management, operation, or maintenance of the property. Really, really important. We talked about insurance in an earlier video. As you probably know, someone can go out and pay cash for a property, and nobody is requiring or even checking that there's insurance on the property. So here at TR Realty, we will not take an account to manage unless the owner has insurance. That's really important. And let's go down to line 45, which is still in paragraph 14A. It says, if any of the above-mentioned insurance policies lapse, or if owner fails to maintain policies in the prescribed amounts, broker shall have the right, but not the obligation, to obtain insurance policies for the coverage and amounts prescribed herein. And that paragraph is really important, and that's why it requires its own initials down on line 49, okay? Insurance, it's just the right thing to do. We have owners who try to get out of that obligation, but it's not right to put a tenant in the property, and frankly, it's not very smart either to have a tenant in a property unless the property is properly insured. And one more thing I want to point out in this paragraph, if we could go back to line 35 toward the end of the line, it says broker shall be named as an additional insured. So it's interesting because this is a relatively recent concept in the standard PMA that's provided by the Realtor Association. Yet, it's something that I've been teaching all the way back to when we opened our property management division in 2011. In fact, before it was written into this agreement, it's something that I had in an addendum to the agreement. I always thought that the broker should be named as an additional insured. Obviously, the association agreed with me, as it is now part of this paragraph. And then in 14B, it talks about the tenant's insurance. Tenants shall or shall not be required to obtain renter's insurance. Always shall. We always want the tenants to have their own insurance because the property insurance is not going to cover personal possessions. So as an example, if the hot water heater exploded and the house flooded, the owner's insurance is going to take care of the hot water heater and the carpeting or flooring or, the baseboard or wherever the damage may be in the property, but it is not going to cover the fact that the tenant left his laptop on the floor along with his 1980s CD collection, which is now all ruined, right? So that's what tenant's insurance is all about, and we should always require tenant's insurance. 15 is a hold harmless paragraph. 16, broker assumes no liability for any damages, losses, or acts of omission by the tenant. Yeah, we can't be responsible if a tenant is in the property and decides to damage that property, although we've had many situations where owners thought we should be responsible for the conduct of the tenant. That would be a pretty slippery slope, wouldn't it? Paragraph 17, owner's responsibility for expenses of litigation. It says, owner shall pay all fines, penalties, or other expenses in connection with any claim, proceeding, or suit involving an alleged violation of any law pertaining to fair employment, fair credit reporting, environmental protection, rent control taxes, or fair housing, including illegal discrimination on the basis of race, sex, color, religion, national origin, physical handicap, familial status, elderliness, that's a hard word to say, or all other protected classes. So yes, the owner is ultimately responsible for the property and everything that goes on there. 17B, fees for legal advice, ultimately the responsible party would be the owner as well. Paragraph 18 talks about representations. Owner represents and warrants that owner has full power and authority to enter into this agreement. And let us zip down to, let's see, this is line 45 toward the end, where it says, owner understands that offering a property for lease while the property is in any foreclosure proceedings without written disclosure is a deceptive trade practice punishable by both a civil fine and criminal proceedings. Owner initials required, again on line 49. I did mention to you at the beginning of this video that property managers are required to check the public records to make sure that there's not a notice of default or a summons and complaint, either of which would tell us that a foreclosure might be coming on the property. So we don't want to put a tenant in that kind of property. It's just not the right thing to do, and you can see the language in the PMA supports that. Paragraph 19 is about common interest communities. So if the property is located in a CIC, that would include condo associations or homeowners associations. Owner understands that the CIC's declaration of covenants, conditions, and restrictions may restrict the leasing of the property, and it is the owner's sole responsibility to determine whether the property is so affected. This is also why we collect a copy of the rules and regulations and provide those to the tenant as well, so the tenant knows exactly what the rules and regulations are. Otherwise, we couldn't hold them accountable. And we want to see the owner go ahead and initial there on line 15 as well. Paragraph 20 is a little tricky. 20A is about early termination. It says this agreement may be terminated by owner before the termination date specified in section 2D by written notice to broker not less than 30 days prior to the termination date specified in such notice, together with a cancellation fee in the amount equal to the management fee that would accrue over the remainder of the stated term of any existing lease agreement or this agreement, which is greater. Let's talk about that a little bit. If we didn't have such language in the PMA, some owners would hire us, get a property fixed up, get a tenant in place, and then fire us. So they wouldn't have to pay any management fees for the duration of the tenant. But that's how we earn our living, is based on that. So we wouldn't want that to happen. And that's why such language exists in here, that if the owner wants to cancel, they're going to have to pay us out through the end of the PMA, the end of the lease, whichever is going to be longer. And if they want us to transfer everything to a new property management company, on line 26, not only would they pay out those cancellation fees, but they would pay a transfer fee as well. My recommendation here is $100. And then it says this agreement may be terminated by broker before the termination date specified in section 2D upon 30 days written notice to owner. So we have the right to cancel this agreement as well, and we've done it many times. We've done it in cases where owners refused to make repairs that we thought were important or we thought, violated the owner's side of the lease. We've had owners who've made, unreasonable demands, refused to fund their reserves, or, we've seen properties go into some state of foreclosure. We've seen owners refuse to renew their insurance, all kinds of reasons that we have had to terminate from our side. And I want to zip down to line 31. It says if owner terminates this agreement prior to leasing the property, owner agrees to pay an additional cancellation fee. My recommendation here is $250. Why is that a little bit more harsh? Well, think about what it is. This is a fee that if they cancel before we've even rented it, which means we have not made a nickel. We've done all the administration, all the paperwork, visits to the property. We have possibly facilitated repairs, maybe landscaping, pool contracting. We've possibly put the property into MLS. Maybe we've shown the property even, and now the owner wants to bail on us before we've gotten $1 out of the property. So that's why there's a higher cancellation fee if the cancellation occurs prior to leasing out the property. Also, we wouldn't be entitled to the payout, right? The management fees that would accrue to the end of the PMA, the end of the lease, whichever is longer. Let's go to 20B. Upon termination of this agreement, owner shall assume the obligations of any contract or outstanding costs incurred by broker under this agreement. And if we fast forward down to line 42, it says, if after termination, broker receives funds which are payable to the owner, broker may deduct an administrative fee of either a dollar amount or a percentage, whichever is greater, before delivering the balance of funds to the owner. So example, if the PMA is no longer in place, either it expired or it was canceled by one side, and then let's say a tenant pays rent to TR Realty, we are entitled to take our pound of flesh out of that. In my recommendation, it should be the percentage, and it should be the same percentage that we indicated in paragraph 3A. Because even though we're no longer under contract, we are obviously still performing that service. Paragraph 20C, say the leasing fee survives. Let's look at that carefully. In addition to the amount specified in paragraph A of this section, if owner terminates this agreement before the termination date in section 2D and or before the property is leased, and within blank calendar days of the termination, the property is leased to anyone with whom the broker has had negotiations or to whom the property was shown prior to the termination, broker shall be paid the leasing fee as set forth in section 3B. My recommendation here for line 48 is to put 180 days. If we did not have this provision, which by the way is called a protection period, basically, we could introduce a tenant to the property. Somehow the owner and the tenant talk directly. The owner terminates the PMA with us, puts the tenant into the property, and cheats us out of our management commissions. So we need this protection period, 180 days is what I recommend. Paragraph 21 is indemnification. Paragraph 22, a miscellaneous paragraph. Let me bring your attention to 22B. Which is the agreement to mediate. I believe in mediation. I believe it is quicker, less expensive, and less painful than litigation. I highly recommend the mediation provision on line 22. Now, for this paragraph to become effective, both parties, meaning the owner and the broker, me, would have to initial this paragraph. If only one party initials it, then it's not going to apply, and therefore no requirement for mediation would exist. So I like mediation. It's not that I like going to mediation. I just like it as an alternative to going to court. So I highly recommend that we talk to our owner about initialing here on line 22. Continuing through paragraph 22, basically some administrative housekeeping issues here, going all the way through, let's see, 23, applicable law is Nevada. 24, this is the complete agreement. 25, we could actually sign on more than one copy when taken together. We do, in fact, have a legally binding contract. I want to bring your attention to page 11, paragraph 26, which is probably the most dangerous paragraph of the entire agreement. Why do I say it's dangerous? It's dangerous because it's blank. And real estate agents, property managers, they feel compelled to write language in here. And the language is often, at best, contradictory, at worst, illegal. Agents should never write language. That's what attorneys are for. That's what brokers are for. Agents should never assume that liability. Typically, they don't have the experience. They don't understand the ramifications. Now, I'm about to read to you some of the things that I want in this section. So this is paragraph 26, page 11 of the PMA. You may need to pause this video. You may need to rewind this video to get the exact language. But if you are a property manager at TR Realty, you are required to input the following language into paragraph 26. There are 5 sections of this, so get ready to make good notes, and you've got to get it word for word, okay? So number 1, which is always required, says, owner hereby authorizes TR Realty to remit owner net proceeds to, and then somebody's name, comma, as well as issuance of all required tax forms in the name of, and somebody's name. So the reason we have this language is because sometimes there are trusts, sometimes there are family situations, sometimes there are language barriers, and often a property owner, the person who's the legal owner, will ask us to pay the owner draw to someone else, to a family member or something like that. So we always need to know to whom to pay. And again, in the case of an LLC, in the case of a trust, we're probably not paying that trust. We're probably not paying that LLC. We're probably paying a person. So this paragraph gives us that authorization for the payment as well as the tax forms. So one more time, item 1, always required, folks. Owner hereby authorizes TR Realty to remit owner net proceeds to somebody's name, as well as issuance of all required tax forms in the name of somebody's name. Let's move on to number 2, which is optional. 2 is optional. It's up to the discretion of the property manager if they would like to do this service. And if they would like to do this service, then this language is going to be required. It says, property manager shall conduct a walkthrough inspection of property, including photos, every 6 months at a cost of, and then we would put in some dollar amount. So right now, with the virus, it's kind of tricky, in which case we wouldn't do the walkthrough, in which case we wouldn't charge for the walkthrough. But if the owner requests it, or if the property manager wants to do it, then we would need to add this language. One more time. Property manager shall conduct a walkthrough inspection of property, including photos, every 6 months at a cost to owner of X dollars, whatever we put in there. Paragraph 3, absolutely required in every case. Owner hereby authorizes TR Realty to sign for and open any mail addressed to owner that is received in our office. TR Realty shall not be responsible for any mail sent elsewhere or not received. So this could lead to a dispute with the owner. We talked about earlier how we need 30 days notice to redirect the mail, change the account information, etc. Well, that's no guarantee that bills are going to be received here. What if, let's say, we are paying an electric bill for the owner during a vacancy, and the bill doesn't come, and then all of a sudden the owner is charged a late fee? How could that possibly be the responsibility of TR Realty? We didn't pay the bill because we didn't get the bill. So paragraph 3, one more time. Owner hereby authorizes TR Realty to sign for and open any mail addressed to owner that is received in our office. TR Realty shall not be responsible for any mail sent elsewhere or not received. Item number 4, which is always required if you are a property manager at TR Realty. Owner agrees to pay for any postage or shipping expenses except for regular mail. All right, so sometimes we have to send things like garage door openers or remote controls or that sort of thing, sets of keys. So the owner is going to have to pay that postage unless it's just regular mail, in which case we pay for it. So one more time, owner agrees to pay for any postage or shipping expenses except for regular mail. And let's take a look at required item number 5 that you would put into the additional terms, exactly word for word of how I'm giving it to you now. Owner agrees to transfer to TR Realty any security deposit funds held by owner within 30 days of effective property management agreement. So, as I told you in an earlier video in this class, we don't allow the owner to hold the security deposit. Those funds belong to the tenant. They need to be in a trust account. So if and when the time comes that they should be legally dispersed, we have those funds to disperse them. So in the case where an owner might have been self-managing or might be with some shim-sham company that allows the owner to hold that security deposit, we want to get it here into our trust account. So one more time on the language. Owner agrees to transfer to TR Realty any security deposit funds held by owner within 30 days of effective property management agreement. All right, so those are the 5 things that we add into the property management agreement, with 1, 3, 4, and 5 being required in all property management agreements, and item 2 only being required if the owner and or property manager agree that those regular inspections will be performed. And folks, every page of this property management agreement requires the owner's name, the owner's initials, and initials by the property manager. When we look at the bottom of page 11, line 27, broker's name, it's actually company name there, should be TR Realty, but all of the rest of that needs to be filled out, printed, and signed. Let's move on to page 12, which is the Exhibit A that we talked about very, very early in this property management agreement. In fact, I think I referred to it in an earlier video as well. Exhibit A is the property information page. It is the page that allows a property owner to set the guidelines within which they are comfortable. Okay, so we're going to look at this, and I'm going to explain these things one by one, but the point of this page is to give us the parameters. And as property managers, once we have an effective PMA, as long as we stay within the parameters here in Exhibit A, we don't need to go back to, in fact, we shouldn't go back to the owner and consult with them on every little decision. It would be a monumental mistake for a property manager to go to an owner and ask if they're willing to accept a certain tenant, as an example, because that is going to open a huge can of worms for issues relating to discrimination. You know, who are these people? What do they look like? Those kinds of things. We never want to do that. This property management agreement gives us the authority to lease the property on the terms contained herein. We need to take that authority and not go back and consult with the owner on every little decision. On line 5 of Exhibit A, we want to put the owner's name exactly as it appears in the tax records. Lines 7, 8, and 9 would be the property address. If it's a condo, we want to get the unit number, we want the zip code, we want everything in there. Line 11 is the date. And then it says on line 13, the parties hereby agree that the term of the controlling RPA agreement is hereby extended for 1 calendar year from the date of this property information form. Any and all other terms of the RPA shall remain the same and in force. And that is how we could extend, right there, we could extend the length of the PMA if that's what we chose to do. And the reason to do it here, some of you might be wondering, well, wait a minute. Brad said earlier that the PMA automatically extends in 1-year increments, right? Well, it does automatically extend unless 30 days written notice is given by other side. However, if we wish to change the terms, maybe market conditions have changed, maybe the rent needs to be higher or lower, or we wish to make any other change, we would do that by using this Exhibit A, and then conveniently it contains this paragraph so that we also wouldn't have to do anything else to extend that agreement. Line 17 talks about existing tenant, if any. So if we were taking over an account that had a tenant already in place, we would want to have that tenant's information, obviously, and that's what that section is about. All right, let's go to line 27, which talks about the acceptable rental rate per month. It has a minimum and it has a maximum. And some of you might be thinking, why would the owner set a maximum rate? Well, the reason that we set a maximum rate is because if the property manager is too optimistic and they put the property on the market for too high of a number, then it's going to sit vacant, right? Obviously, the more we charge, the more risk of vacancy there is. So that's why we want the owners to go along and give us their consent for a minimum that they're willing to accept, as well as a maximum that we're allowed to advertise the property. We don't want a situation where an owner comes back to us and says, well, you put the property up for rent too high, and that's why it's vacant, and that's why we never got a tenant, so you're fired, and now my mortgage is in default, right? We don't want that situation, so we always want to fill in the maximum, and we want to fill in the maximum rate here in line 27. And very similarly, on line 29 is the acceptable lease term. What is the minimum? What is the maximum term? You might be thinking, why would anyone want a maximum term? Well, there's all kinds of reasons. Maybe they want to sell the property in the future. Maybe they want to move in to the property in the future. Who knows? Maybe they want to renovate the property. Line 31, will pets be considered? This cannot be left blank, folks. Well, none of these can be left blank, right? Yes or no. And if we put yes, that pets will be considered, the tenant must complete that application for pet approval. We can't just give blanket acceptance to any kind of a pet, whether they're bringing a 7-pound Chihuahua or they're bringing a 600-pound horse, right? So we have to get consent, and then we have to actually check out the individual pet, make sure the pet is licensed, make sure the pet is acceptable if there's community standards, that sort of thing. So yes or no, pets will be considered. And I want to make a very, very important point here. And if I have any property owners listening and watching this video right now, this is something for you. Service animals are not pets. They cannot be restricted. Folks, it doesn't matter if you check no, pets will not be considered. If a tenant has a service animal, the service animal goes in. That is not something that can be restricted as per federal law. Okay? So you can't expect a tenant to pay a pet deposit or pet rent. It's not a pet. You cannot say a tenant is in violation of a no pet policy. It's not a pet. A service animal is not a pet. And there is no property manager in Nevada or anywhere in the United States, for that matter, who could somehow prevent a tenant from bringing in a valid service animal. Federal law protects service animals, okay? Then it says, will smoking be permitted in the unit? Yes or no, cannot be blank. So smoking takes into account not just cigarettes, but other devices that are smoked as well, such as pipes, cigars, marijuana. Some might even say vaping. If you'll allow smoking, then smoking is allowed and people can smoke. However, even though marijuana is now legal under Nevada law, we can't prohibit someone from using marijuana, but we can prohibit them from smoking the marijuana inside the property. That's why it says in the unit. They could go out to the patio, they could go to the backyard, and they can smoke if that's what they want to do. So it's very important that we make a choice here. On line 35, will Section 8 be considered? In the upcoming version of the property management agreement, they will be changing the term Section 8 to housing choice voucher. Section 8 is a term that is no longer used, but the association has not yet changed this form. So will Section 8 be considered, yes or no? Folks, I like Section 8. It is very dependable income. It's true that the property has to be up to standard, but properties should be up to standards anyway, whether they're Section 8 properties or they're not Section 8 properties. So the property has to be inspected. But the thing about a Section 8 or housing choice voucher property is that they are really, really in demand. It is rare that you would have much, if any, vacancy on a property like that. And if you're watching this video and you're thinking, oh, Section 8 tenants damage properties, man, you're living in the 1970s. That's not how it works. If someone damages a property and it's reported to the housing authority, that person can lose their Section 8 privileges for life. And as an experienced property manager managing hundreds and hundreds of properties at TR Realty, I can tell you that the rate of damage in a Section 8 property is not one drop higher than the rate of damage in any other kind of property. So I'm hoping that you're not saying no to Section 8 as some sort of a backdoor attempt at discrimination of any sort. Section 8 helps people when they need a helping hand, as many of us have in our lives. So I encourage Section 8, and I really want our property owners to say yes to this whenever possible. Going to line 39, the CBU and mailbox number, parking space number, gate code, alarm code, all of those things we need to know. 43 starts to talk about the insurance company, the policy number. Is broker listed as an additional insured on line 45? That always needs to say yes, because as you know from watching this video and from reading this PMA, it is required that the broker be named as an additional insured. Line 51 starts the home warranty company. If applicable, we want to get all of that information. A warranty is not required. It's just smart. And at the beginning of this video, I did talk about how we want to collect that warranty information. Here's how we do it. And then on line 54, it says authorized agent for broker. That would be the property manager who is authorized to sign this property management agreement on my behalf and dated as well. And then the owner also signs to the right on line 54, dates, and prints his name as well. Please don't forget initials down the bottom of every page, including this one. And that is a quick but good look at the property management agreement. If there's something that I skipped because I thought it might be slightly less important than other provisions, feel free to text me at any time or email me, and I will clear that up. But folks, there is the property management agreement. So some of the things that I would like to stress in relation to the PMA. You know, the PMA is a contract between the owner of the property and the broker. It is not a contract between the owner of the property and the property manager. It's a contract with me, with the broker. And if it ever calls for it, I do have the right to change property managers at any time. It would be just like changing the designated agent for a listing, right? Listing agreement belongs to the broker. I have the right to change. There are times that I need to do that. The property management agreement allows the property manager to sign leases on behalf of owners, like having a limited power of attorney. I stressed that. I talked about that. We talked about staying within the parameters of everything that the owner indicated in Exhibit A as well. That's why it's really important that we get Exhibit A filled out very, very carefully. Folks, don't let the owner of the property be the co-manager, okay? They're not hiring a co-property manager. They're not hiring an assistant property manager. They're hiring a property manager. And by the nature of the property management agreement, they are conveying certain rights to us as the property management company. And it is a common mistake that property managers make where they run back to the owner on every little thing, even though the property management agreement clearly states they don't need to. It's terrible. You are setting yourselves up for failure. You are wasting an unbelievable amount of time. You are setting yourself up for unbelievable headaches. Things like arguing over a $50 repair. It's just the wrong thing. Don't let the property owner be the co-manager. Get the PMA signed, the rights convey to us, and we manage the property from that point forward. And certainly never let an owner do their own repairs. If you come in contact with someone who wants to hire us and they tell you they want to do their repairs, go ahead and do all those repairs before the PMA is signed. Once the PMA is signed, we are legally required to use only properly licensed and insured vendors. We cannot have the owner going into the backyard of his property, climbing up a palm tree to cut down some dying fronds, right? We can't have that. Property owners cannot do their own repairs. Now, the repair limits, that is a frequent source of dispute in the PMA. We covered it. If it's not clear to you as a property manager or prospective property manager, go back in this video and listen very carefully how I talk about the repair limits, setting the threshold under which we have the unilateral right to do repairs, over which we need consent. Make sure that you get that clearly. Make sure that the owner understands the reserve funds are automatically replenished before we pay the owner draw. And now the owner can send us funds if needed, or if not, we're going to take it out of the next rent, the next owner draw. Okay? But they can always replenish those funds by remitting funds to us at their own discretion. Remember, when you're going out there and you're competing for property management accounts, one of the great things we do is we pay bills for the owner at no additional charge. There are some companies that offer bill-paying services, but they typically charge for them. HOA bills, taxes, insurance, utilities, mortgages, whatever. We are happy to do that at no additional cost. Let's talk a little bit about something that gets property managers in trouble. Let's talk about the concept of commingling. To commingle funds means to mix funds that belong to one party with funds that belong to another party. We cannot do it. We will not do it at TR Realty. It is a big deal. Not only is it the law, but it's good business sense not to commingle. That's why we don't have a credit card available, because we could cause an expense to be incurred not ever knowing if we would get funds to pay that bill. And if the owner didn't give us funds to pay the bill, how would we pay it? We'd have to take those funds from somewhere else, and that might be commingling. So mixing funds that belong to one party with funds that belong to another party, that's commingling. We don't do it. We'll never do it here at TR Realty. It is a problem, so be very, very mindful of never even coming near the gray area of what commingling really is. And the last thing that I'd like to cover in this particular video is the TR Realty property management disclosure. So the TR Realty property management disclosure was mentioned at the very beginning of this video when I talked about all of the requirements. So please go ahead, get that form in front of you. As you know, anytime I call a form the TR Realty this or the TR Realty that, it should tell you that it's our own form. And of course, our logo is always prominently displayed on any of our own forms so that no one ever thinks it's a form that comes from the division or from LVR. So let's take a look at this property management disclosure. Again, it is a requirement here at TR Realty that all property owners sign this. It says, this document shall serve as a list of important disclosures to you, our customer. TR Realty and its property managers believe that these disclosures may benefit you while making decisions regarding the management of real estate. The first paragraph talks about vendors. Property manager shall be responsible for ensuring that each vendor that is consulted, hired, or compensated to perform any service and/or repair to any property that is managed by TR Realty is properly licensed and insured in the appropriate venue in which the service and/or repair are performed. Persons and/or companies without the proper licenses and insurance may not be utilized at any time or for any reason. In the event any vendor is discovered not to meet these standards, any outstanding payment due shall be withheld indefinitely. In no case may property owner perform repairs to property once a property management agreement is effectuated due to the substantial liability that may be incurred by TR Realty and its property managers. We just talked about that a couple of minutes ago. Furthermore, in the event property owner performs or causes to be performed any service and/or repair to the managed property at any time, any and all liability and/or expense incurred shall be the sole and unequivocal responsibility of property owner, including but not limited to medical, legal, insurance, and financial. Property owner shall be responsible for any bills or financial obligations pertaining to the property, even after termination of any property management agreements between the parties. The next paragraph talks about repairs and maintenance. Repairs and maintenance contracted or conducted by property owner are full legal and financial responsibility of property owner, right? So if an owner goes out there and hires some vendor, even if they're licensed, to perform a service on the property, unbeknownst to us, or without our consent, basically they're doing the co-managing here, right? We're not going to be responsible. They're completely responsible for payment. They're responsible for performance. They're responsible for, somebody getting hurt on the property, all of those things. The third paragraph, each property owner must procure and maintain current and valid property liability insurance at all times and provide proof of same to property manager. Also, TR Realty must be named on the insurance policy as an additional insured. We've talked about that. A property owner shall be responsible for connecting all utilities in the owner's name during any periods of vacancy. Let's talk about the next one down, which is prepaid rent. In the event tenant prepays rent, TR Realty will release rental income to property owner on a monthly basis, and any prepaid rent for advanced periods shall be withheld accordingly. Yeah, so if you've got a tenant who, let's say they pay a year's worth of rent in advance, we don't release that to the property owner. We only release it monthly. And that's because we want to make sure if something happens to that property, it burns down or it's foreclosed or whatever, that the tenant doesn't lose that money. So that's why we only release the money to the owner as the owner is providing the service of residency. The next one says W-9 IRS disclosure. Property owner must provide to TR Realty either a signed W-9 or W-8 for foreign investors prior to the release of any rental income. Until such time as TR Realty has either a verifiable W-9 or W-8 on file, rental income will be withheld and shall be released only upon receipt of the W-9 or W-8. Property owner may wish to consult with a licensed qualified tax professional. So we can take an account. Actually, we can take it without a W-9 or W-8, but we can't pay the owner. So we've had cases where months and months and months have gone by, and the owner reserves and owner draw are sitting together in the trust account until such time that the owner comes up with a W-9 or a W-8. If they don't need or want the income, they're not providing the documentation that we need to release those funds, then so be it. The next one, broker will issue an IRS Form 1099 in the month of January, immediately following any calendar year in which property owners earned rental income totaled $600 or more in the aggregate. Replacement 1099 forms upon property owner request and after notification has been sent that 1099 forms have been made available shall be provided to property owner for a fee of $25 each. So every January, my accounting team will prepare and provide the 1099s. We like to do it electronically. Unfortunately, some owners insist on paper. But nonetheless, prior to the deadline of January 31st, we will alert the property owners that the 1099 is ready for them. If the deadline comes and goes, they've not responded to us in any way, and then they pop up in February or April or whatever, and they say, oh, my dog ate the 1099, or I didn't pay attention to the emails, then there's a fee of $25 for us to provide a second copy of the 1099. No charge to provide the first copy, of course. The next paragraph is very closely related to the one that we just talked about. Electronic delivery consent. Property owner hereby agrees to the electronic delivery of IRS Form 1099 to the email address provided by a property owner in this disclosure, as well as to the suppression of paper versions. The suppression of paper versions means if you agree to electronic delivery, we are not going to send out a paper version any longer, okay? And then it says at the end of this paragraph, if electronic delivery is returned as undeliverable for any reason whatsoever, property owner hereby agrees to hold TR Realty harmless. Yes, so if you disconnected your email address, and that's what you gave us to send the form, and you didn't give us a new address, I'm sorry, that's on you. The next paragraph is the ACH disclosure. TR Realty highly recommends that property owners set up ACH. ACH stands for Automated Clearinghouse, but it means electronic payments for receiving rental income. Care must be taken when entering account details into the owner portal, as typographical errors will result in a $20 return fee assessed to property owner. If property owner requests that ACH be set up by property manager, property owner hereby agrees to hold TR Realty and property manager harmless in the event of an error and understands that a return fee of $20 shall be assessed to property owner in the event of an error, regardless of the reason or cause of the return. So if they put in their bank account information incorrectly, or they give us the wrong information, and then their payment bounces, basically, it's returned because the account information is wrong, the system is going to charge a fee, and that fee is going to be on them. That's $20. And then it says ACH payments are faster and safer than paper checks. TR Realty is a green company and therefore prefers that all property owners use ACH in lieu of paper checks whenever feasible. Yes, we definitely don't like paper checks. The next paragraph here talks about the U.S. bank account disclosure for ACH. Property owner must establish and maintain a bank account in a financial institution located inside the United States in order to receive rental income by ACH. We're not trying to discriminate here if someone has a foreign bank account. It's not our limitation. It's actually imposed by the software company. There's nothing we can do about it. ACHs can only be conveyed to U.S. bank accounts. And then it says, until such time as TR Realty has obtained U.S. bank account information, rental income shall be withheld and shall be released upon confirmation of the account. And then the final paragraph in this disclosure says, paper check disclosure. If property owner prefers to receive rental income in the form of a paper check in lieu of ACH, please don't do that. TR Realty will not be responsible in the event of loss, theft, or destruction. Any request to replace a paper check for any reason whatsoever shall incur a fee of $30 assessed to property owner. Twice each month, on or about the 13th and on or about the 25th of the month. TR Realty generates paper checks, which are then issued to property managers. Property managers are instructed to distribute the checks in a timely manner thereafter. Please contact property manager should you have any questions regarding the distribution of paper checks. Paper checks went out with the Reagan administration. Please, folks, get on ACH, be green, be efficient, have documented, verifiable conveyance of funds. Please use the ACH. And then it says, by signing below, You're acknowledging that TR Realty has explained this disclosure to you, our customer. In the event that any part of this document requires additional explanation, or you should want additional assistance understanding any part of this disclosure, please ask your TR Realty property manager or seek assistance from an independent source. Your signature indicates that you have read and understand this disclosure. Property owners need to sign, they need to date. Don't forget the initials down the bottom of the page. I would like to thank you for watching this video. I hope it was informative for you. If you are licensed with another brokerage in Southern Nevada and would like to talk with me, please text me or visit our website. See you next time.